Hi, everybody. Welcome to Trial Alchemy. And in this podcast, I talked with some of the very best plaintiff and defense civil trial lawyers from around the country, and they're members of the American Board of Trial Advocates, ABOTA. We talk about what works and what doesn't work in civil jury trials. Now, these days, to become a member of ABOTA, you have to have tried at least 9 civil jury trials to conclusion. Back when my guest Roger and I were admitted, the rule was 20. But in addition to having tried real cases, you also have to be found to be an excellent trial lawyer who's honest, civil, and professional in their interactions with their opposing counsel and with the court. So I'm Monty McIntyre. I'm your podcast host. I've been a California lawyer since December of 80, and I've been a member of the ABOTA since 1995. I had the honor of serving as the president of our San Diego ABOTA chapter in 2014. For most of my career, I've been a civil trial lawyer trying plaintiff and defense cases in lots of areas like business, tort, employment, real property, and insurance bad faith. But these days, I primarily work as a mediator, arbitrator, and a referee at ADR Services. I also help lawyers keep up with the new case law with a publication called California Case Summaries. And I also help lawyers become better civil trial lawyers with this podcast where they can learn from outstanding trial lawyers from around the country. So the Trial Alchemy podcast is brought to you by California Case Summaries, and there's 2 ways to subscribe. Number 1, you could subscribe to one of our 4 options. And number 2, you can mediate with me, and there's a way that you could have an individual attorney subscription for a year, or you can also get a law firm subscription where all the lawyers in the firm can get the summaries by also mediating with me. So without any further ado, let me introduce my guest, Roger Dreyer. Roger is an exceptionally great civil trial lawyer. He's up in Sacramento, California. And the emphasis of his practice is specializing in the areas of catastrophic injuries, wrongful death, public entity liability, general negligence, and products liability. Roger has tried in excess of 150 civil jury trials in 13 different counties for his clients. Now, that's a high number, and not many lawyers get to that number. So he's exceptionally well qualified. He's obtained for his clients in excess of 35 7-figure and 8-figure jury verdicts, more than 200 settlements in excess of 7 and 8 figures, and he has obtained multi-million-dollar verdicts in complex wrongful death cases, catastrophic brain and spinal injury cases, as well as products liability and public entity actions. He was sought out by the ownership of the National Football League Oakland Raiders to try a complex business fraud case as lead trial counsel for the Raiders against the Oakland Alameda County Coliseum and other defendants. And that resulted in the highest business fraud verdict in Sacramento County history, $34 million. Some other excellent verdicts he's obtained is he obtained $31 million, I believe, against Mastercraft Boats in a defective product case, and $75 million against Ford Motor Company in a defective product case. And then in another case that got a lot of notoriety, in a wrongful death case due to intoxication by water, he obtained a $16.7 million verdict. Roger is a member of the American Board of Trial Advocates. He served as the president of the Sacramento chapter of ABOTA in 2002. He also served on the National Board of Directors for a number of years. He's also been named as the Trial Lawyer of the Year in 2010 by the Consumer Attorneys of California. And there are several California ABOTA chapters. They're called Cal ABOTA, and once a year they select a Trial Lawyer of the Year. And Roger was named the Trial Lawyer of the Year by Cal ABOTA in 2004. So without any further ado, Roger, welcome to Trial Alchemy. I'm delighted to have you as a guest today.
Thanks, Monty. I appreciate the interest in being invited.
So Roger, you've tried a lot of cases, and I want to start our podcast with this one. You've had a lot of satisfying trial results, but why don't you tell us about one of them and why it was satisfying?
Well, I don't know that satisfying is the right word. I would say that, and picking one over the other is also like trying to pick your favorite child, and I have four. Um, I think that every case has its own impact on you. Um, and clearly some of the cases that we've been successful on, the ones that you mentioned, like against Mastercraft and against Ford, had big time impact on the product manufacturer. And so that's extremely gratifying. You're when you have those kind of cases, you get those kind of results. Um, you obviously have someone who's been very, very badly injured. So it's
Right.
not like a satisfaction as much as it's, doing what you were designed to do and achieving a result for your client. The water intoxication case, Jennifer Strange, was also, it changed the radio industry in terms of contests and understanding the accountability. That was a case where they could, you know, uh, blame her for drinking because she was doing it voluntarily. But it was important for that family to go to trial on that case to like clear her name and get the truth out. Because as you know, a lot of these cases we have to deal with urban legends and uh, misperceptions that people have of the civil system, and getting to the truth is really crucial. Uh, the Raiders trial was 6 months long, and that's I don't know whether satisfaction is the right word. The fact that I survived it, and being in trial for 5 days a week, and having to deal with Al Davis every day, including the weekends, was, it was a life-changing trial in the context of just understanding how hard you have to work and what you have to do and be prepared each and every day and what you have to put into it. So that's probably as close as I've ever come to killing myself, just by
Wow.
but it also, I had a great, which I'm sure you're familiar with, a great, probably my number one mentor was Harvey Levine. And I remember calling Harvey on that case when they were interviewing lawyers, and when Mr. Davis asked me if I'd represent them at trial, and I talked to Harvey, and he said, because it was an impossible case. I mean, we were basically trying to prove that a group of four gentlemen who weren't very sharp could defraud Al Davis. And that was the basic function of what we had to prove. But Harvey said, hey, you have to take that case. Those are the kind of cases that don't come along. And if you get the opportunity to do it, they'll define you as a lawyer. And it made me test the bounds of what I could do, uh, what I could put myself through. And it was in a discipline I'd never done before, business fraud.
Right.
And I wasn't being driven by the engine of empathy that people would have for my client, because not there was not a single juror that felt sorry for Al Davis, uh, or the Ravens. But it's that case defined my skill, allowed me to do things that I never done before, became very capable, just because you're doing it day after day, getting lots of reps, doing unique things. And that was in 2003. And that was really computers and PowerPoints and things like that were just starting to get engaged in the courtrooms, and we operated at a very high level. So
Mm.
um, that was, I don't know if the word satisfying is right. It's more of survival, but it was a great experience. But I've had so many really remarkable clients that I've been able to represent. Been just very, very lucky, very fortunate.
Well, a 6 month trial is a very long trial, and you're going through the grinder, having to try that case 5 days a week. A lot of times you get to have one day off, but you had 5 days a week plus Al Davis all weekend. That would be a tough thing.
But think about the jurors. I mean, we started with six alternates because we knew it was going to take a long time because of
Yeah.
the breadth of what the claims were. And we got down to the final 12 about a month before the verdict. And that's part of, in my world, your world, juries, there's a magic to being in the courtroom. There's something that happens to people. Doesn't mean it's always right. There are lots of times where juries will, get it wrong, and an outside influence or a bias will impact them. And that's the whole chemistry, if you will, of trying cases. It's not for everybody. A lot of people say they want to do it. A lot of people will say that they are trial lawyers. But to me, it is the definition of practicing law to be in front of people and that are not lawyers, not educated in the law generally. So I've just been very fortunate.
Well, I'm glad Harvey, I had the pleasure of knowing Harvey Levine, and he was a great trial lawyer down here in San Diego and very capable. But you proved with that case something that goes along with things I've always said. If you know how to try a case, you can try all kinds of cases. So you tried this business fraud case that was totally out of your area of expertise, but you had to learn and grow. And that's one of the things you get to do as a trial lawyer: learn, grow, expand, deal with new stuff.
Yeah, I think that that case, I mean, I was in ABOTA a long time before that case. Obviously,
Yeah.
that's for a lot of different reasons. I'd had a lot of success in courtrooms and just really incredible cases against public entities, which are very hard, as you know. And the that case demonstrated to me because I was trying the case against Jim Brosnahan, who was reputed to be, a world famous trial lawyer, and it allowed me to see uh, the level of which I could do it. And that sounds very arrogant, but it just that it I always felt like I was the best person in the courtroom when I'm trying cases, and you have to have that belief in yourself that you are
Right.
practicing your skill. And that was it really at the highest level, and it demonstrated to me that you have to be confident in going into the courtroom, and confidence is built by preparation and by a belief in yourself. And so it certainly honed me, but also steeled me in a way that nothing else could have done. And I've tried long cases. I've had a case against Nissan that went 4.5 months, and 4 days a week in a products case is a lot more compelling and crushing, especially when you have a quadriplegic that's depending upon you,
Yep.
than Al Davis. I mean, that became more of a skill contest than uh, than than for an individual. And that's the beauty of the civil practice, at least from the plaintiff side, is you get to know your clients. In today's day, there are a lot of lawyers that parachute in, go to different places, try different cases, kind of a swashbuckling hired gun type of plaintiff's lawyer. And you obviously have to be very good to do that. I've been very fortunate to have my own cases, develop my own cases, be retained by the client who sought me out to represent them, and then take it to trial. You develop a level of a relationship that is, it's intense. You find
Yeah.
out people, whether it's a death case where you get to know someone who you never have met through others, or where you see what your clients go through, like brain injury victims, and just the ability to connect with them. And speaking of confidence, the ability for them to be confident in you, because this is a foreign environment. They're putting everything in your hands. So it's a pretty powerful process.
It is a powerful process. And you alluded to this earlier, but preparation for trial is so important. So your experience in having tried these over 150 cases, I'm sure you've developed some ways that you get prepared when you get down to knowing, yes, we're going to have to try this case. What's your method? How do you go about doing it? How do you get yourself ready so you know you've done everything you need to do before that trial really starts?
Well, I actually really start preparing from the very beginning.
Yep. All
From
good trial lawyers do that.
and every depot, I have a methodology now where, and I've been practicing this for a long time, is my exhibits in depositions, I'm already creating my exhibit list for trial. And I've learned that, especially in the complex cases, that if you're not thinking that way, you're not going to be ever able to pull it together to go try the case. So my exhibit list is 80 to 90% done when other people are just starting to go through and try to figure out what exhibits they're going to use. They're marked. I put someone on the stand. I'm referring to an exhibit that we did 3 years ago. It's the same trial exhibit. Uh,
Yep.
so
That's smart.
preparation starts from my perspective, and what I teach my people and my kids who are now with me is the importance of getting it started at the very beginning and thinking in the context of a trial, because it's a lot easier to resolve a case that's ready to be tried than have to settle a case because you're not ready to go to trial. And that's where I see
Right.
a lot of people letting people down because they're depending upon you. And if you're saying, hey, this is the right number and you should settle for this or we could lose, it's so easy for a plaintiff's lawyer to convince a client that they should settle their case because of the power position. I think it's just really important for a lawyer who represents plaintiffs to make sure that you're thinking about what's going to happen at the end. I want my clients, and I tell them all the time, 10 years from now, I want you to look back and go, wow, Roger Dreyer was great. He did a great job for me, as opposed to that dirty bastard made me settle the case, because
Yeah.
I'm dealing with, uh, all these problems and they never were brought up. So it's a relationship that you have to really respect.
So what you're doing in preparing from the beginning is you probably have your whole case organized as you're going through it, getting discovery, taking depots, and you're organized for trial so that you are ready when you get to trial. You've already been preparing that whole stuff. You know what your exhibits are going to be. So that's really important and that's very helpful. What other kinds of things do you do to get prepared in that final prep time, whether it's a few months before or whenever it is? So you know you're going to have to spend hours and hours doing this, but how do you get yourself ready?
Well, you have to learn to operate without sleep or not as much sleep.
Uh,
Uh, and I think it's not so much a game plan, it's just a lifestyle. Uh,
mhm.
Accepting the responsibility of being a trial lawyer. The person that you're representing is depending upon you. That's the ultimate motivator, and in terms of effort, uh, you're never prepared, fully prepared, because there's always something more you can do. But I've got a case going out in December 1st in Monterey. I've been getting my witnesses organized and ready, and I don't sit down and write out what I'm going to do. I keep a lot of it in my head, but I know how I'm going to do it. I'm organizing my calendar early on, and you can't really do it Monty for every case. So because I have cases that are in conflict. Any good trial lawyer is going to have lots of conflicts, and some cases settle last minute, some cases don't settle, and you just have to
Right.
be ready to pivot to a new case. And I've had cases where I was not as prepared as I'd like. Today, it seems like it's much more common to have another lawyer with you when you try a case and prepare a case, and that's our model now in this office. Um, but the first 100 trials I had were all by myself. Uh,
Yep.
and the Raider Trade case, we had a team of lawyers, but I was doing the witnesses, I was doing the prep, I was doing everything. And So, I mean, I had a great young guy who ended up and has become a very good trial lawyer on his own right, who would do the occasional witness. But that was part of our tactical strategy. You know, we wanted to have that connection with the jury with one person, not a phalanx of lawyers like the defense had. Uh,
Right.
so it's a preparation. It's like being a pirate, right? It's more of a guideline than a rule. And I don't want people to listen to this and go, God, that sounds impossible. You prepare every case. You can't prepare every case. You just, if you work on it from the beginning to be prepared to go to trial, it's easier to get it as prepared as you need it to be.
There you go. That makes sense. So when you're in trial and you've tried so many of these cases, so what part of the trial, in your view, is the most important part of a jury trial, and why do you feel that way?
Well, I think, I don't know what other lawyers would tell you, but to me, it's all about jury selection. And that is because you can be the best, the most skilled examiner on the planet. If you have some time bomb sitting on that jury as a plaintiff, if you're going to lose. And I've
Right.
lost cases where clearly I was the best lawyer in the courtroom and I did a fantastic job of presenting the evidence and I won the case, but I didn't win it with the 12 people that I needed. I've had jurors, absolutely hysterically crying and I tried so hard, Mr. Dreyer, and I just couldn't get them because they came in with a preconceived view that we could not clean out. And
Mm.
people have their own lens. We all look at things through our lens because we think we're comfortable. We think that's got to be it. And the reality is, you're looking for a jury, in my opinion, that's going to be open-minded, and that's really impossible to get because not very few people are completely, truly open-minded. But you have to convince them or get them in the mindset that they will be open-minded because everybody thinks they're a good person and a good citizen and you know they're going to do the right thing, but the right
Right.
thing depends upon the individual. So the skill of picking a jury, which is something again people just don't get the opportunity to do, and there's classes and there are workshops and ABOTA does different things on jury selection. You tell people, but putting it into practice and being on your feet and how you go about the task of jury selection to keep it interesting so that they pay attention, including the people behind you pay attention, and the judge doesn't say, hey, you've been going 2 hours here. We need to move it to the defense. And that's, I think, the most important part. It's not the most fun part. It's the only time I have found myself just drenched with perspiration because of anxiety
Yeah.
of working, trying to keep in mind what you're learning, trying to keep it engaged. I mean, opening statements, closing arguments, that's the fun stuff that you could do without a note. But the jury selection is unscripted and you have to hit certain things and ask certain questions and promote honesty and authenticity, which is hard to do.
Yeah. So let's talk about that. How do you promote the honesty and authenticity that you're trying to promote? How do you go about doing that? You're in this setting where you got these strangers, they're in a strange place, they don't know this system, they don't know the judge, they don't know you. How do you give them that kind of feeling of comfort?
It's more than comfort. I think it's trust.
Yeah.
Uh, they have to. I'm a plaintiff's lawyer. I'm trying to make money. I'm trying to drive up their insurance rates. I'm trying to do all sorts of very nasty things to them because that's all they hear. I'm also perceived as being someone who is slick and will cheat and lie. And we have to deal with movies like Liar Liar that are hysterically funny because there's kernels of truth to what's going on. And my cousin Vinny, things like that. But ultimately, the trial lawyer is a hero because they ultimately get it right. The trust thing is the most important thing. So again, as a plaintiff's lawyer, I've had defense lawyers that have absolutely lied and cheated, and I've pointed that out, and I've gone after them in closing, and the jury is uncomfortable. Like, God, you were awfully tough on Mr. Smith, Mr. Dreyer. And they will give the defense so much more latitude than the plaintiff because the defense is not asking for money. We're asking for money. How do you put into dollars and cents the loss of a 4-year-old who's drowned in a pool? How can you put a number on that? How do you put, a number on somebody who's been consumed in a fire? And so it's so uncomfortable for them that you need to demystify it. You need to explain it. You need to do it in a way that lets them relax and understand, oh, I can do this. And then I use other jurors to show other jurors how they should think, what kind of juror they will be. Or are you like this guy who's more worried about attorney's fees? I mean, and I don't do it in a judgmental sort of way. I'll say, are you open-minded, or do you have a vision that Mr. Johnson has over here, that he believes that I'm in it for the money? And I deal with advertising lawyers. I deal with contingency fees. I deal with, what perceived of frivolous lawsuits and things of that nature, because that's one of the ways in which you engender honesty and trust, that you're talking about difficult things. And if you're able to get them to relax and listen to you on these difficult topics, then they get interested, then they get engaged, and then they want to participate. And that's, I think, the most important thing, is getting that agreement between you and them that they're willing to participate and do the right thing without telling them this is what you need to do. So it is an art form. They call it an art form, but it's also having instincts that you have to get in different places. You can't go out and get trials as often. I mean, I've got two of my kids work for me, and they've been in trials, but it's, if you have a great case, you settle it. The cases you try are very hard cases, or somebody on the other side has made a monumentally bad judgment call, and those are rare and far and few between. I mean, when they happen, and then the pressure's on, you better deliver. But the reality is, I think my skill set in picking jurors is because I have 4 kids. I had to communicate with 4 kids. My wife of 45 years is a defense lawyer. I have to communicate with her. I've coached baseball and I've coached soccer for my kids, all the way to 18, from 7 years old to 18.
Yep.
And if you are able to communicate to children or to teenagers or to brand new adults, and everybody's different. I've coached girls and boys, and I think honestly that communication skill, and deal with their parents, that communication skill has helped me tremendously be able to communicate with regular people, that which is what your jury is. So that I think is when people say, well, I can't get juries, I can't get the opportunity to do it. You actually can do it all the time, but I think by activities that you engage in, and dealing with young people, I think, is one of the best ways to learn how to talk to people.
Yeah, I think you're absolutely right about that. And that's a great way to get information that'll help you in your picking of juries. So when you've got a potential juror on the case and you are talking with them and they don't look like they're going to be the kind of juror you want, you think there may be a challenge for cause, do you do any things to try to make sure you can get them um, challenged for cause successfully? Because the trial judge may try to rehabilitate them.
Well, that is, again, we now live in a time. I was fortunate. I grew up in a time where you had judges that were career judges that were really good. You'd have the occasional, maybe not such a great judge, but people that took great pride in what they're doing. And I'm not saying present judges don't, they do,
Right.
but they have the same skill set. The lawyers that got elevated to judicial positions, for the most part, had been in courtrooms. They knew what courtrooms were because everybody was in courtrooms back then. Uh, so it's hard to predict. So I think my practice on cause challenges is to again develop the relationship of trust, even with people who I know are not going to be terrible jurors, and get them to agree to things they just simply can't be fair and impartial. And I might say impartiality is the most important component of that phrase. You just can't be impartial. And that you understanding that situation, and you give them an analogy that they can relate to, like, your wife, you're in a criminal case and your wife was raped and now you're on a rape case. Can you really set that all aside? Sounds like that'd be pretty hard to do.
Yep.
Uh, so I give them an opportunity to admit that they shouldn't sit on the case because of that bias. Now, the more skilled jurors who want to get you, which they're out there, I got nothing better to do. I'm going to sit on this case and I'm going to jack up your world, Mr. Dreyer. I've had jurors who have said things that are clearly bias related to go, no, I can absolutely put that aside. 100%. That I will not, I understand the rule. I will set it aside. And they'll do it in the most convincing way. And the key is not to be fooled by that. And the only way to really learn that is to get fooled. And I've been fooled. And uh, I, I just think that you have to get the bias and the impartiality issue established 100% so the judge can't waffle on it. And because it's not just the judge, it's also the defense lawyer who's going to try their very best to say, well, come on, Mr. Smith. I mean, if you're sworn in as a juror, you telling
Right.
me you can't be honest, you can't be truthful, you can't put aside that. It's very rare. And I have to be able to educate that person to say, because I will say, now, Mr. Jones here, he's going to get up and he's going to try to show that you don't really feel that way. Is he going to be able to do that with you? And give them the education on how to get off the jury, and or not intentionally, but just so that they understand. And if they don't, I then use that person as a foil with other jurors.
Right.
And but again, it's certainly not precise or guaranteed. I remember I had a juror once in a med mal case I tried, and she was a beautiful woman, and her husband was an orthopedic surgeon, and she was on this jury. And she couldn't have been nicer to me. She couldn't have been more alluring. And I was a young guy, and here's this young, beautiful woman who's, oh, Mr. Dreyer, I totally agree with you. Yes, I can certainly set that aside. In fact, my husband, he knows there are bad doctors out there. So I think I can absolutely. So she totally conned me into
Hmm.
putting her on. And then soon as they were sworn in, she went from being this wonderful, sweet person, just sitting back in her seat, crossed her arms, and that was her the rest of the trial.
Oh
Uh,
my goodness. Yeah.
it is that's a lesson. I mean, I tried that case back in the 90s. I can still see her sitting there. It is something you have to put your ego aside. You have to have a lot of ego to try the case and feel comfortable to do it, but you also have to understand that you are not omnipotent and can read people's minds and uh, not be fooled. You have to be able to carefully analyze who the person is and make that critical decision. And then the chess match of striking and when you pass and when you don't and things of that nature.
Right.
Very fun and very exhilarating, but also extraordinarily debilitating. And I just feel once that jury's picked, I'm in a great position because I've worn the other side out. They know now they can't compete. I do try to break the spirit of the other side, and I see them try to do things I've done. Like I remember everybody's name. I quickly will memorize people's names. I've learned the skill to do that. Who doesn't like to be called by their name as opposed to juror number 11? Uh,
Sure.
and then when they start to do it and they mess up, and it just creates an advantage. And I think a good plaintiff's lawyer who's confident and capable is going to be able to establish an advantage right off the bat.
Yeah, in the jury selection process, how do you use the mini opening these days to help you with what you're trying to accomplish?
Yeah, mini opening is just like the world's greatest invention for us. You'll see people on the defense abuse it and you'll get upset, but it's actually it's where you get to test. I have my co-counsel always do the mini opening, and I have them say what the number is we're going to talk about. We're going to talk about $40 million. Is that going to be a problem for you? I just want you to know this is the case. They talk about the case and they say, and we're going to be asking for $40 million. Is that going to be a problem? Sometimes the defense lawyer goes crazy, but it's a totally legitimate question. And not to anchor, it's really to find out if someone just can't even go there. And I've had a variety of things happen when I do that. So I just think it's important. It's a good test. It's not me that's doing it. And then when I'm doing jury selection, I can kind of take a step away from that. But it does allow, because some jurors go, God, I heard that number. There's no way I can sit on this case. I just can't do it.
Yeah.
And no case could be worth that amount of money. And boom, you have cause. So
Yeah. Well, it's smart that you have somebody else ask the question, but it's also smart you get it out early because you're going to talk about that in voir dire when you're talking to them.
yeah, then it's the elephant in the room is there, and we can all look at it and see it. It gives great practice to the person that I have trying the case with. They get to do an opening,
Yeah.
uh, and 3 to 4 minutes. They have to be concise. They get to, because a lot of this, as you know, is people look at it, they see, yeah, I want to do that, and then when they get up on their feet and they realize I can't do this, you
Right.
know, or they freeze, or they have it. The mini is such a short amount of time, and there's zero pressure because you're going to have the old guy with the white hair. He's going to get up and actually do the jury selection and actually do the opening statement. This is just me getting some reps. And so I think the mini opening is huge. I've had defense lawyers absolutely violate the rules, and argue their case versus give an opening statement.
Right.
And you just turn it to your advantage, you know.
Yeah.
So I think they're very valuable, and and the code says you get one. I mean, you ask for it, you get it. So
You now get it. Right. It wasn't true initially, but it is true now.
yeah, yes.
Yeah. So now you've got your jury, you've got your 12 people, maybe however many alternates you need. Now you're going to give your opening statement. So, what's your strategy? What are you trying to accomplish? How are you telling your story to get the effect or persuade in the way that you want to?
Yeah, the opening is the start of that trust, where you're communicating what you're going to present, and to do it in a compelling and interesting way so that they know this is the story. This is like uh, the book jacket that makes you want to buy the book, or the trailer on a movie that makes you watch the whole movie, is to see
Right.
it. And it's a type of storytelling. Uh, Sometimes I might go too long, being very candid, to be as detailed as I can be. And I've learned that I think over the course of time that you don't need to talk at them that long. You need to get through, tell the story, let them know what's going to happen, and then give them the story. But don't overpromise. You got to just give them the information you can provide. And if there's something that you think is problematic, you want to own that in your opening, which is, that's kind of very basic trial practice 101. You don't want them to get up and say for the first time, well, Mr. Dreyer didn't mention in his opening is this guy had two previous spine surgeries.
Right.
That totally whacks your whole case. So, and your credibility. So the standards for a plaintiff's lawyer are 1,000 times harder than for a defense lawyer. Now, a defense lawyer, I'm sure, would say, "Yeah, but we've got a tough job and we got to deal with all the emotion." But people fight the emotion big time. They want to fight the emotion, and they don't want to be feeling sorry for people. They want to show how stoic they are about it and that the law will play out. But it's a bond. The opening is a bond.
Yeah, you're developing their trust, and your credibility is very important in the trial, isn't it?
It is everything, especially as a plaintiff's lawyer,
Yep.
because when you get to the end of the case and you're talking about what you think is reasonable compensation, they have to believe what you have to say is worth listening to and believing. Because you want them to take your numbers back there and say, well, Mr. Dreyer thinks it's this. And when someone fights him and says, well, he only said that because of X, I need them to say, no, no, it makes sense. He believes it.
So, in terms of the opening statement, how much are you trying to tell the story either using videos or pictures or other things in addition to your speaking?
Yeah, I think that in today's world, everybody's so used to seeing things and images. So yeah, you definitely, have some kind of images, some of the evidence that they're going to see. You don't want to play your best stuff. Uh, you want to play your intriguing stuff, things that make people want to watch. Um, you have to play uh, uh, items that will attract their interest so that they can stay to the end of the movie. But it's you've heard lawyers say it. I mean, it's like our pledge to you. Here's what I'm going to prove. Hold me to my pledge. That's
Right.
establishing that connection and bond. But every case is so different. Like if I have a complicated case that has details of medicine that I will start. That's my opportunity to educate them on what the medicine is and or the structures of the brain or things of that nature. Then they go, wow, this guy really knows his stuff, as opposed to
Right.
just running past it. But you got to walk that fine line of not trying to be impressively knowledgeable and off-putting. And so it is a very important. I've heard lawyers say most important thing is the opening statement because most people make their decision after the opening. I think that people make their decision as they're processing. I think it starts with the jury selection. They're making their decision who I'm going to listen to, who I'm not.
Right.
And if again, going back to jury selection, if you do a really great, thorough job, the defense lawyer doesn't even want to get up and do anything because they don't want to look bad or they don't need to do it. Well, now they're used to listening just to you and how you treat the staff, how you treat the judge, how the judge talks to you. Those are all nuances that they got nothing else to do. They're watching everything. So the opening, again, confidently given, uh, which comes from just knowing your facts, knowing it cold, and believing it. You can tell at the very beginning. I think people can understand. Does he really believe this, or is he just saying it?
Well, I've heard different lawyers talk about how they tell the story, and do you have an order of the story that you tend to use? It probably changes with the nature of the case.
Yeah, it's really hard to define it any more than it's got to be a logical flowing story. So it's going to be chronologically correct. But I've had cases before where I've told the ending before I've told the story. Uh, and it just depends on the specific set of facts and being a capable storyteller. I'm not a good storyteller, I think, in terms of mesmerizing orator. Uh, but I think it's authenticity and believing in what you say. People can feel that, and
They
they
can.
yeah they have to want to hear you. And I don't talk at them. I don't order them around. I try to be like the maitre d' to okay, here's your feast. Here's where we're going to go, and here's what we're going to be able to do.
So you've given your opening statement, and that's all completed. Now, as the plaintiff, you get to put your case first. So what kind of thinking and strategy goes into who you call as your first witness?
All again goes to how I want to communicate and present the story. On a brain injury case, for example, I would probably have someone, not my best witness, but a good witness to lay the land on who the person is and who they were and what kind of things they did, and so that they get a baseline of my client. And that's pretty much the case in most cases. I want to start the story before the incident happens. But there are times when you start with a bang, and it's and I've changed it last minute just because of who the 12 people are that are now sitting there, and
Right.
got to make adjustments. You got to be the really good trial lawyers have the ability to pivot immediately and do things that you go, whoa, that's creative. That really makes sense now that I think about it. I mean, how many times do you watch a movie and then something happens, you go, oh, it was right there. I could have seen it. And that's really what we're doing is we're trying to keep them interested and engaged. And so the first few witnesses do that. My I rarely call my client at the beginning of a case. My client is generally at the very end of my case. Um, Brain injury cases, I don't have my client sit through the trial because by the time my client comes in, they've heard the story, so they understand while they look normal, they're not. If I have a client with a brain injury sit there from the beginning, looking normal, talking to me, relaxed, and that defeats the whole purpose of what we're trying to present.
Right.
And it's not that I'm trying to be dishonest, or it's just that people are on their best behavior, and a brain injury isn't presented by way of physical ability to see it. It's how people live their lives or can't.
Right.
Uh, so different cases require different order. Um, and it really depends on the specifics of the case.
So it sounds like often your client in a plaintiff's case, maybe near the end or at the end. Uh,
Yes.
and where do you put your experts that you're going to have to call in that order?
Well, again, depending on the case, the Mastercraft case you mentioned, my first witness that we called was a architect, a building architect, a marine architect,
Yep.
and had to explain what a boat is, what a vessel was, what are the different compartments, educate them right at the beginning so that, oh, okay, this is interesting. So I have called experts at the very beginning. You have to build to a crescendo. So you look at what parts of your case you have to have certain experts to lay the foundation for other experts. Brain injury cases, I generally finish strong with it, but you're going to have a couple of people that are covering the brain, and so you have to be very careful. You don't want to shoot everything down in the very first expert and then have cumulative objections with the next one. You need to be thinking about how they integrate with each other. But it's again, it's got to be interesting and intriguing for a jury. Otherwise, they lose interest and they start thinking about what they're going to cook for dinner, or
Right.
I get out of here to go see my son play baseball or something of that nature.
Now, in presenting your case, you're mostly doing direct exam, but you're also going to be doing cross exam when the defense is putting on their case. So, um, when you're doing cross examination of witnesses, I think of cross as something where the classic cross is the closed cross controlling the witness. But I also think there are certain people like Jerry Spence and others who had an open cross style. Do you use different types of cross to do what you're trying to do with the witnesses when you're doing cross exam?
Yeah, I think that again, it depends on the witness, depends on your preparation, depends on the deposition, depends on whether you have a deposition. Uh,
Mm-hmm.
and so for me, cross-examination is again being very prepared and knowing your case. You should know the case better than the witness. You're in a position to walk the witness off the plank without the witness knowing they're on the plank. But I've done cross-examination in less than 8 minutes, and it's very effective and it's intentional. I've also done cross-examinations of experts for hours and where I wear them down because I know the case better and I know where their vulnerabilities are. I've had great experts on the other side, and I know I can't do medicine with them. So I'm looking at bias. I'm looking for where I have holes to say, I'm done with this witness. How can anybody believe this witness after I go through the bias? I don't want to empower them. But also, I mean, I'll never forget. I had a med mal case a long time ago, and I don't do med mal anymore. But as a young lawyer, um, and I knew the medicine because the guy that was testifying was board certified, big shot, academic at UC, very, very smart guy. And so I got him because I knew the layers of the skin, the epidermis, and everything. This was a otolaryngologist that I got him off track on something else, and then I switched back to medicine, and he screwed up, and he didn't the different layers correct, and then I pointed that out to him, and performed for the jury. Going, I thought you were the man. What you don't know this? With the clear inference that if you don't know this, how do you know anything else? And that got him rattled. And those are the kinds of things, those are moments. Yeah, I couldn't have planned that out.
Right.
Just having the ability, and people say instinct. Yes, but I don't think it's instinct. I think it's learned behavior. It's you learn how to do things and you have the information in your brain prepared so you can pull it out when you need it. There are plenty of times where I'll see a lawyer who's done a good job and then they keep going and they lose the effect of what they had.
Oh,
And,
yeah.
once, and then, is this the right moment to finish my cross-examination? Have I made my point and can I sit down? Or I really think I've done it, but I got this one more question, a topic I want to go into. Do I do it or do I not? So it is really a quick twitch muscle that you have to be able to do.
Yeah, there's a lot of art in that where you really have to know when it's time to stop. And you may have another page, but sometimes you're better off just, you made your point, sit down.
Yeah, I had a lawyer, a really talented trial lawyer, an assistant U.S. attorney who I got a great relationship with as a young man. And, this is back in the early 80s, okay? There's
Right.
not an opportunity to try cases back in the early 80s. So when people complain to me today, I go, that's on you. That's not on the system. You can go try cases. You just have to try hard cases. What you're telling me when you don't get trials is telling me you won't try hard cases. That's all that tells me. Uh, but he told me, I said, how can I get experience on doing cross-examination? Because you got to do it. Well, depositions, as a civil lawyer, you don't have that excuse. All you need to do is go take depositions. And now I
Right.
see so many people that just don't want to do the work. And I don't hate to sound like an old man that, the younger generation. You want to learn how to cross-examine? Go take depositions. Start working on your skill set there.
Well, taking depositions teaches you how to ask questions, whether it's direct exam or cross, and you really have to learn that skill to be a good
And then
trial.
you get to read it and go, oh
Yeah.
my God, I can't believe how many times I said the word and, or I said or I know, or something of that nature. That's the greatest teacher is watching your own stuff or watching you on videotape. That's invaluable for young lawyers to do. You can read stuff, and this individual told me, I think 5 books on trials equates to one trial. That's what he told me. And I don't know whether it's true or not. But as a young lawyer, I thought, okay, I got to go read trial books. And you can't be somebody else. You can't do what, Harvey Levine did or
Right.
something as in his book or Mo Levine or someone like that. you have to be yourself, which is, you know, an old tired expression, but it's true. Uh, but you got to have some arrows in your quiver that you can pull out. And every time I've read anything, I've I've gotten an arrow and or watched a movie. I mean, the verdict with Paul Newman is should be required viewing for all lawyers, especially young lawyers. They don't even know who Paul Newman is or the story. And I've seen that movie probably 40 times. And I have learned something each time I've watched that movie.
Great
And
movie.
it just, as a trial lawyer, and when you initially watch it, I guess, especially as a plaintiff's lawyer, I'm going, this is terrible. That's not the way lawyers are, blah, blah, blah. And as you see him matriculate through that movie and grow as a person and as a lawyer, it's an inspirational movie. And there are so many scenes in it that, you know, violations, things you don't do, you know, you don't ever ask a question you don't know the answer to, which is, I don't necessarily agree with that rule. Sometimes you make
I
a
don't either.
sometimes you don't. Uh, but that is, if you really watch that movie, or you watch really any movie that deals with trial practice, you'll learn stuff because they clearly have consultants. Whoever consulted on that movie was a genius because there were so many things buried in that movie that, you know, everything from a really bad judge to a deceitful defense lawyer, conniving, cheating, to a client, to a plaintiff's lawyer, to your assistant, to everything. It's just the pressure. That movie is amazing.
Yeah, that's a great movie. Well, one of the things you're mentioning, and it's so true, is you can learn things from people, whether it's watching them try cases, whether it's, you know, reading books or looking at videos and this and that. But you also have to make sure you do what you can do because you can't apply everybody's methods if it doesn't fit with you. So you have to get these arrows, but you have to figure out which are the arrows you can use.
Yeah, it's very true. Not everybody's Robin Hood and can't shoot the arrows as well as others, but whatever it is, you gotta have the equipment and understand that you're not going to necessarily use all of it, but you better pack up and you better have enough ammunition and to
Yep.
do.
So when you get down to the final argument stage, and in your cases, most of the time you've got some serious injury. And I think a very difficult thing for juries is how do you put dollar amounts on non-economic damages that are such important things in life, loss of love, companionship, support, those kinds of things. How do you help them? What do you do to help them do their job and be able to put those numbers on the verdict?
I think you have to be a human being, number one. Um, you have to have already gotten them into a mindset, capacity to compensate, and that starts with jury selection. And then you have to find different things to analogize to. Great trial lawyers are also like great comedians. They steal material from everybody.
Yep.
Generally, I've seen people like, for example, great trial lawyer Brian Panish down in LA. Brian can quote from the Bible. Uh, if I try to quote from the Bible, I'm sure that a thunderbolt will come through the courthouse and get me. But I've tried it and it just doesn't feel right. I've seen lawyers recite lyrics from a song and it's just so beautiful. You go, oh wow, that I'm going to do that. And then I'll find a great phrase in a Bob Dylan song. And sometimes I can do it and sometimes I can't. Excuse me. Depends on the case. And it depends on how you feel. And that again goes to the, you know, your name of your show, the alchemy of being a trial lawyer is sometimes it's you have to do a different potion and a different mixture to put in to what you're doing and on communicating numbers and getting people to go with numbers there if you haven't established a relationship it doesn't matter what you're going to ask and they have to believe that you believe it and if a lawyer gets up and argues, Joe Schmo told me I should argue for $10 million on this. God, I don't think it's worth 10, but I'm going to say it. Uh, Juries can feel that. You're just a money peddling lawyer.
They
Uh,
can feel it. Yep.
so it's again, you have to believe what you're doing. You have to believe in the numbers you're using. And I've argued for some big ass numbers, and I'll test it, with people who don't know any of the facts, nothing that the jury's gotten.
Right.
And you learn things by testing. I will ask people, what do you think? Here's the case. How do you feel if I said $30 million? And I know who the person is, and if that person says something in terms of information, I'm going to pay attention to it. I'm not, I, if you just go out and talk to people so that people tell you how wonderful you are and agree with everything you're saying, you're not going to learn anything. So you have to test it.
Yep. I always have to test it. You probably test it with the focus groups, but you also test it with individuals as well, right?
Yeah, there are a lot of people that believe in focus groups, and there's a lot of people that think getting that data is really important. And again, for me, I've done it, and I haven't used a focus group in a decade, simply because I have the advantage. I mean, I've tried probably 200 jury trials now. And so for me, I'm very comfortable of knowing how human nature is. And I think people lean on focus groups because they think that's going to, give them the answer. Great story for you is on the Raiders case. Okay, we had unlimited money. I did a focus group at the Grange Sheridan with 250 people, and they were all wired up. This is back in 2003. We, I had the person who ran it. She was very, very famous, had written books on, picking a jury. She wasn't a lawyer, but she had all the psychology. She'd done all these high level trials according to her. And we sat in a room, I'll never forget it, circular table. And at the end of the day, we'd go through the jurors, and I'd have all the different representatives of the organization, including Davis. And she positioned herself right next to me. And then we'd go around the room, and every time she said, well, I agree with Roger. I think that's what this person is XYZ. This is why we want this person, or why we don't. And she added nothing to it, the process. And that really opened my eyes. I think a focus group is helpful for young lawyers, or even lawyers who've tried 20, 30 cases. It's helpful because you're getting reps, you're getting practice of articulating your case. So regardless of what the focus group does, you're practicing in a way you wouldn't have practiced otherwise. And you will get some nuggets, but that's not your jury. And you're gonna have somebody different. And so to me, and I know I stand probably in a smaller group, and that's simply because I think I'm okay without a focus group. So I'm not saying don't use focus groups. I'm just saying that for me, it's not part of my process.
That's perfectly fine. Well, listen, Roger, this time goes by so fast, and it's always a wonderful conversation. And I'm going to have to bring us to a close here, but I want to end with this question for you. So, what is the best advice that you could give somebody who's a younger lawyer who wants to be a good jury trial lawyer, civil jury trial lawyer? Maybe they've tried no cases, maybe they've tried one or two. What advice would you give them to go on that path?
It's hard to give advice because I mean I'll probably be saying the same thing that most old trial lawyers would say, which is go try cases. But you have to have the opportunity, a legitimate opportunity. And some offices don't give people opportunities to try cases. So work for a place that will give you that opportunity, not just say it, but do it. It's okay to be a second chair and see it happen. But what I tell my people here is I want you to try a case by yourself. I want you to rise and fall by yourself. And if I'm trying a case with them, they've got a huge safety net. and they don't learn what it really means to try a case, in my opinion. You have to be by yourself, and you're going to make mistakes, and you have to be unafraid, and you got to be fearless, and you got to be willing to put yourself out there. And the best way to do that is to have a client you really believe in. But you may not get that. You may have a case where it's not that good. Might be a slip and fall. Might be that your client was involved in a collision, but he did something wrong, or they were intoxicated. Nothing's going to be perfect on your first trials. And you learn more from trying a bad case than from trying a good case. And you learn a lot more from a loss than you do from a win. And you have to be willing to put yourself out there and take the risk. And it's always easy as a plaintiff's lawyer to not try a case. They offered me enough money. And I've seen people do all sorts of mental gymnastics to rationalize why they took the number. Whereas a month before, they were telling me something completely different about the value of the case.
Right.
You find the mettle of the person at that time. Once you walk through the court, into the courtroom once and announce your name and you're ready to go, and you survive it, you're not struck by a lightning bolt. That's the key, is you got to do it. There's no substitute for it. There's no ability to take a shortcut.
Yep, you have to be willing to try it. You have to be willing to risk defeat. And anybody who's tried cases will lose. Hopefully not very often. Roger, that's great advice. Thank you so much for being a guest today, and thanks for sharing your experience. I think people are going to learn a lot from this, so really appreciate it. Thanks for being a guest on Trial
Thanks.
Out.
I appreciate it. I appreciate the opportunity.
All right, everybody, that's it for this session, and until we meet again, do well and be well. Bye-bye now.